Muslim law is a rich and complex system that governs various aspects of life, including religious, charitable, and social matters. In India, Muslim law is recognized as a personal law and is applied to Muslims in matters such as Waqf, Mutawalli, Pre-emption, and gifts. This unit explores the essentials of a valid Waqf, the role and powers of a Mutawalli, the law relating to Pre-emption, and the requirements for a valid gift under Muslim law. Understanding these concepts is crucial for appreciating how Islamic principles shape legal and social practices, especially in the context of property and charitable institutions. Waqf is a permanent dedication of property by a Muslim for a religious, charitable, or pious purpose. Once a waqf is created, the ownership of the property is transferred to God, making it inalienable and non-transferable. The law of waqf is governed by Islamic principles and in India regulated by the Wakf Act 1995. This institution plays a significant role in supporting religious and charitable activities, ensuring that property is used for the benefit of the community or specific individuals, depending on whether the waqf is public or private. According to Abu Yusuf, a Hanafi jurist, waqf is the detention of a thing in the implied ownership of God, with its profits always applied for the benefit of human beings. In India, waqf can be public, benefiting the community, or private, such as waqf al-awlad, which is for one's family. The concept emphasizes the spiritual and social significance of dedicating property for the welfare of others, reflecting the core values of Islamic law. First essential for a valid waqf is permanent dedication. The property must be dedicated perpetually, meaning it cannot be temporary or revoked once created. Temporary waqf is invalid under Muslim law. The intention behind this requirement is to ensure that the property remains dedicated to its religious or charitable purpose forever, serving the community or beneficiaries without interruption. Valid waqf requires a clear declaration of intention by the founder, known as the waqif. This intention can be expressed orally or in writing. If the property is immovable and worth over 100, registration is compulsory under the Registration Act 1908. The clarity of intention ensures that the dedication is genuine and not accidental, providing legal certainty and protection for the property and its beneficiaries. Person creating the waqf, called the waqif, must be a Muslim, of sound mind, a major above 18 years, and the owner of the property. These requirements ensure that the dedication is made by someone who fully understands the legal and religious implications and who has the authority to transfer ownership. This prevents disputes and protects the interests of the intended beneficiaries. Property dedicated to waqf must be tangible, such as land or buildings, and transferable under law. Movable property can also be dedicated. This ensures that the waqf is based on real assets that can generate income or serve a purpose, rather than abstract or intangible items. The law requires that the property be clearly identified and capable of being used for the intended religious or charitable purpose. Waqf must be created for a lawful purpose, which includes religious, pious, or charitable objectives. Examples include the construction or maintenance of mosques, running madrasas or hospitals, and providing for needy persons or orphans. The purpose must not be against Islamic principles, ensuring that the waqf serves the community in a manner consistent with religious values. Once a waqf is created, the ownership of the property passes to God. The waqf loses personal control over the property, and it becomes inalienable and non-inheritable. This spiritual transfer of ownership underscores the religious significance of waqf and ensures that the property remains dedicated to its intended purpose forever. Mutawalli is appointed to administer and manage the waqf property. The Mutawalli acts as a trustee, not an owner, ensuring that the property is used for its intended religious or charitable purpose. If no Mutawalli is appointed by the waqf, the court can appoint one. This system provides accountability and proper management, safeguarding the interests of the beneficiaries. A waqf must take effect immediately during the waqf's lifetime. Conditional or future waqf is not valid under Hanafi law. This requirement ensures that the dedication is genuine and not speculative, providing immediate benefit to the intended purpose and beneficiaries. Judicial decisions have clarified the essentials of a valid waqf. In Abdulrahim v. Narayan Dazarur 1923, the Privy Council held that any property dedicated permanently for religious, pious, or charitable use is a valid waqf. In M. Kazim v. Asghar Ali 1932, it was reiterated that ownership must vest in God and the intention must be genuine. These cases highlight the importance of legal and religious requirements in creating a valid waqf. To summarize, a valid waqf must meet all essential requirements: permanent dedication by a competent Muslim for lawful purposes, transfer of ownership to God, and proper management. Once created, a waqf becomes irrevocable and binding, serving as an important institution in Islamic charitable and religious life. Muslim law, a mutawalli is the person appointed to manage and administer waqf property. He acts as a trustee or caretaker, ensuring that the income from the waqf is used for the intended religious, pious, or charitable purpose. The mutawalli's role is similar to that of a manager or trustee in secular law, carrying significant legal and moral responsibility. Mutawalli must be a Muslim of sound mind, a major 18 years or above, and competent to manage property. In some cases, a non-Muslim may be appointed if religious duties are not involved. The founder waqf can appoint the first mutawalli, but if not, the power goes to the court or the waqf board in case of public waqfs. These requirements ensure that the mutawalli is capable of fulfilling his duties responsibly. Mutawalli has only those powers given by the waqf deed or recognized under Muslim law and court decisions. Key powers include managing Wakf property, collecting rent, maintaining buildings or land, leasing property with reasonable terms, appointing employees, spending Wakf income according to the purpose, engaging in litigation, and leasing property for a reasonable term. For leases over 3 years, court or Wakf board permission is required. Mutawalli cannot alienate Wakf property, meaning he cannot sell, mortgage, or gift the property unless absolutely necessary and with court approval. This restriction protects the property from misuse and ensures it remains dedicated to its intended purpose. The Mutawalli's powers are limited to management and administration, not ownership. Mutawalli must act honestly and diligently, maintaining proper accounts and records of income, expenses, and leases. He must preserve the property, ensuring it is not wasted, damaged, or misused. The Mutawalli cannot use Wakf property for personal gain and must execute the purpose of the Wakf strictly as declared by the Waqf. These duties ensure accountability and proper administration. Mutawalli can be removed by court order or by the Wakf board in case of mismanagement, breach of duty, insolvency, fraud, incompetence, or incapacity. This mechanism ensures that the property is always managed by a competent and trustworthy individual, protecting the interests of the beneficiaries and the integrity of the Waqf. Abdulrahim v. Naryandas, 1923, it was held that a Mutawalli is a manager, not an owner, and has only limited powers. In Ali v. Jaffer, 1932, improper alienation of Waqf property by Mutawalli was declared invalid unless prior approval is taken. These cases reinforce the legal boundaries of the Mutawalli's role and the importance of proper management. Mutawalli is a guardian and administrator of Wakf property, carrying legal responsibility and moral trust. While empowered to manage the property, he must always act in accordance with the object of the Wakf, the interest of the beneficiaries, and within the limits of law. This ensures that the Wakf continues to serve its intended purpose faithfully. Pre-emption, called Shuf'a in Arabic, is a right of a co-owner or neighbor to purchase immovable property in preference to a stranger when the property is sold. It is a right of substitution, not ownership, allowing a person to step into the buyer's shoes by paying the same price. This principle aims to avoid inconvenience and disputes that may arise from strangers entering shared or adjacent properties. Shuf'a means joining or sharing. The object of pre-emption under Muslim law is to prevent intrusion of strangers, protect co-ownership and neighborly relations, and ensure peaceful enjoyment of land or dwelling. This right is rooted in communal harmony and the protection of social relationships, reflecting the values of Islamic law. Under Muslim law, the right of pre-emption can be claimed by 3 classes in order of preference: co-sharer Shafi'i Sharik, participator in amenities Shafi'i Khalat, and neighbor Shafi'i Jar. The co-sharer has the strongest claim while the neighbor has the weakest. This hierarchy ensures that those with the closest connection to the property have priority in purchasing it. Claim pre-emption: the right must exist at the time of sale, and the claimant must be a qualified Shafi. Pre-emption applies only to the sale of immovable property, not gifts, inheritance, or Waqf. The claimant must follow strict formalities including immediate demand talabai muwazabat and demand with witnesses talabai ishhad. Failure to follow these steps defeats the right. Talabai muwazabat, or immediate demand, requires the preemptor to express his desire to claim the right as soon as he hears about the sale. This prompt action is essential to preserve the right of preemption and prevent disputes. The law emphasizes the importance of timely and clear communication. Talabai ishhad, or demand with witnesses, requires the preemptor to declare his intention before witnesses and ask the buyer to return the property. This step ensures transparency and provides legal proof of the claim. Both demands must be made promptly and properly to validate the right of preemption. Right of preemption is recognized under Muslim personal law, but is also subject to state laws and general legal principles, including equality and freedom of contract. In Bauram v. Bajnath Singh, Air 1962 SC 1476, the Supreme Court held that preemption based on religion or caste is unconstitutional, but preemption based on property rights is valid. This ensures that the law is applied fairly and without discrimination. Person who is not a neighbor, co-sharer, or participant cannot claim preemption. The right does not apply in cases of gift, inheritance, or Waqf, as these are not sales. Additionally, if the procedure is not followed properly, the right is lost. These limitations ensure that preemption is reserved for those with a legitimate interest in the property. Law of preemption under Muslim law is rooted in communal harmony and protection of social relationships. While recognized as a personal right, its application in India is now regulated by constitutional principles and state laws, ensuring fairness and non-discrimination. This balance maintains the integrity of the right while respecting broader legal values. Under Muslim law, a gift hiba is defined as a transfer of property or ownership made immediately and without consideration by one person, the donor, to another, the donee. This definition applies to both movable and immovable property. Once validly made, a gift is irrevocable except in certain cases between spouses. Gifts are a simple yet powerful way to transfer property, reflecting generosity and goodwill. For a gift to be valid under Muslim law, 3 essential elements must be satisfied: declaration of gift by the donor, acceptance by the donee, and delivery of possession. These requirements ensure that the gift is genuine, voluntary, and properly executed, providing legal certainty and protection for both parties. Donor must clearly express an intention to make a gift. This declaration must be voluntary and made with free consent. The donor must be a Muslim of sound mind, not a minor, and the owner of the property. These requirements ensure that the gift is made responsibly and with full understanding of its legal and social implications. The donee must accept the gift during the lifetime of the donor. If the gift is not accepted, it is not valid. The donee must be in existence at the time of the gift and capable of accepting it, or acceptance can be made by a guardian if the donee is a minor. This ensures that the gift is meaningful and properly received. Possession must be transferred to the donee either physically or symbolically. Actual or constructive delivery is necessary to complete the gift. Without delivery of possession, the gift is incomplete and invalid, unless the donor and donee are living in the same house and the property cannot be physically separated. This requirement ensures that the gift is not merely theoretical but actually received. In Abdul Rahim v. S.K. Abdul Zabar 1925, it was held that without delivery of possession the gift was invalid. This case underscores the importance of transferring possession to complete a valid gift under Muslim law. Legal precedents reinforce the strict requirements for making a gift. Under classical Muslim law, no writing or registration is required for a valid gift, even for immovable property. However, under the Transfer of Property Act and Registration Act, registration is recommended for legal safety if the gift is in writing and relates to immovable property. This flexibility makes gifts easy to create but also requires careful proof of intention and delivery. A gift can be made inter vivos, meaning between living persons. It must not be for future transfer. This requirement ensures that the gift is immediate and effective, providing real benefit to the donee without delay or uncertainty. Under Muslim law, a valid gift hiba requires 3 essentials: declaration, acceptance, and delivery of possession. Unlike contracts, consideration is not needed and gifts can be oral. These simple rules make gifts easy to create but also subject to strict proof of intention and delivery, ensuring that the transfer is genuine and effective. While both Wakf and gift involve the transfer of property, Wakf is a permanent dedication for religious or charitable purposes, with ownership passing to God. In contrast, a gift is an immediate transfer of ownership to another person, without consideration. Understanding the differences helps clarify the legal and religious significance of each institution. The role of Mutawalli in Muslim law is similar to that of a trustee in secular law. Both are responsible for managing property for the benefit of others, but the Mutawalli's powers and duties are defined by religious principles and the Wakf deed. This comparison highlights the unique features of Islamic charitable management. Application of preemption in modern Indian law is shaped by constitutional principles and state regulations. While the right is rooted in Muslim personal law, its use is now balanced by broader legal values such as equality and freedom of contract. This ensures that preemption is applied fairly and without discrimination, maintaining social harmony. Muslim law plays a vital role in shaping social, religious, and charitable practices in India. Institutions like Wakf, Mutawalli, Pre-emption, and Gift reflect the values of generosity, community welfare, and legal responsibility. Understanding these concepts helps appreciate the diversity and richness of Indian legal traditions. This unit has explored the essentials of a valid Wakf, the role and powers of a Mutawalli, the law relating to preemption, and the requirements for a valid gift under Muslim law. Each concept is rooted in Islamic principles and adapted to Indian legal context, ensuring that property and charitable institutions serve their intended purpose with integrity and accountability. Conclusion: Muslim law provides a framework for managing property and charitable institutions with fairness, responsibility, and religious significance. The essentials of Wakf, Mutawalli, Pre-emption, and Gift highlight the importance of legal clarity, proper management, and community welfare. These principles continue to shape social and legal practices, ensuring that property is used for the benefit of all.